welcome back to a new episode of The Law Beneath the Waves. This episode is a special one, as for the first time in the series, we turn our focus to single domestic jurisdiction, and we're going to discuss about New Zealand to better understand how seabed governance is shaped from within. To do so, we're going to take a broader perspective, the management of natural resources. Because to understand how seabed minerals are regulated, we first need to understand how a state organizes, balances, and governs its natural resource. New Zealand offers a particularly fascinating case, not only for its well-known commitment to sustainable management, but also because of the coexistence of legal system, that of the states and that of Indigenous people. This dual framework raises fundamental questions about governance, rights, but also decision-making when it comes to the management of natural resources. In this episode, we're going to explore the historical foundation of this system, how rights over land and ocean resources have been recognized, shared, and contested. But we're also going to look at how New Zealand defines and implements sustainable management and how Maori perspectives on environmental stewardship may align or differ from that of states and industry perspectives. We turn also to the questions of governance and co-management. What does it really mean in practice? Do Maori communities have a genuine role in decision-making? And how competing interests, for example, between conservation, fishing, and resources extractions are balanced? Finally, we examine also the legal dimension through key cases, such as the Trans-Tasman Resources litigation, which has really shaped the debate on seabed mining in New Zealand. What do these legal battles tell us about environmental protection, regulatory frameworks, and the recognition of the plurality of legal orders? Through these domestic lens, this episode actually offers a deeper understanding of how law, policy, and plurality of legal system interact to shape the regulation and governance of the seabed. Let's dive in. Welcome to a new episode of The Law Beneath the Waves. Elizabeth, I'm super happy to have you actually on the episode today. Also because it's the first episode we're going to dedicate to the domestic practice. And we're going to talk about New Zealand and deep sea mining, but we're going to actually take a broader angle and mainly discuss actually the management of natural resources and what makes New Zealand actually quite special actually about this type of management of natural resources. So New Zealand is an island nation in the Pacific, a beautiful island nation, which has one of the largest exclusive economic zone and continental shelf in the world. Usually people don't really know that about New Zealand, so I think it's nice to say it. It's called also its indigenous name is called Aotearoa. It's a very beautiful name. It's a former British colony and a Commonwealth law institution, jurisdiction, which was founded upon the signing of Te Tiriti. Sorry, I'm not really used to pronounce these names, which makes it really interesting because this treaty, as well as customary law, actually recognize Maori's rights to natural resources and certain marine areas and resources. So there's a coexistence of states and Maori rights, which leads actually to the co-management of resources. And it's mainly what we're going to talk about it today. The chapter also mentioned at the beginning, and especially I know Roberts, which was the lead author of this chapter, has worked a lot on it. He mentioned that there's very little information concerning environmental and ecosystem vulnerability, which makes it difficult actually to manage more specifically marine areas and resources. So maybe for the audience, one of the first questions will be actually to go back to the historical background of New Zealand. As I mentioned, it's an extremely beautiful place which has a very strong culture, but also on the legal point of view, since it recognizes actually Maori's rights, it will be actually good to explain the foundation, the legal foundations actually of New Zealand. Could you tell us a bit more and explain this and how actually the current legal system has been built? It would be very nice. Thank you.
Sure, thanks, Virginie, and it's great to be here. Yes, New Zealand, Aotearoa New Zealand does have a very interesting constitutional context. So it was, as you mentioned, colonised by the British, and the Treaty of Waitangi, or Te Tiriti o Waitangi, which is the Maori language version of that treaty, was signed in 1840. And that document in it recognised ongoing Māori authority, political and legal authority, a Māori term called rangatiratanga, over natural resources, over lands, waters, and treasures. And that includes the marine area. And of course, before the British arrived, and actually the French came down here too, there was a bit of a tussle between the French and the British for a while as to who was going to try and put up a flag. But before the Europeans arrived, of course, all of Aotearoa was governed by the Indigenous people, by Māori, and they had a very extensive legal system and political system and a complex resource management system, in particular over the ocean, because they are Polynesian peoples, they were voyagers and navigators, and also there were no native mammals in Aotearoa, so birds and fish were really, really important food sources for the Indigenous peoples in Aotearoa. And so when the British arrived, they recognised this, and so there was this treaty signed which did recognise ongoing rights and interests of the Indigenous peoples over natural resources, including natural resources in the marine area. And there's been some controversial there have been a number of controversies in terms of interpreting what that treaty really required and what it required in terms of things like fishing rights or rights to take resources from the ocean or from the foreshore and seabed, as well as who actually owns areas in the marine space and in the coastal space, which have gone before the courts over the years since then. And it hasn't always been plain sailing, to use a pun, but definitely there is a really rich body of jurisprudence in this space. There is a very rich body of custom and of our courts applying customary law, which is tikanga Māori, and what that would say in terms of resource management, resource exploitation. And there have been a range of treaty settlements, so that cases have gone before the Waitangi Tribunal and other courts, and then there have been settlements between the Crown and Indigenous Māori tribes. And so that provides for a really rich basis for this ongoing collaboration between the state and the Indigenous tribal people who still assert and want to have recognised their political and legal authority in the marine space.
Of course, a very different model than the one of Australia, for sure.
Yeah.
Yeah. So historically, how control actually of, let's say, spaces and resources has been actually shared or not shared between the states and the Maori? How, practically speaking, it's been implemented, this issue of control?
So it sort of depends which part of the marine and coastal environment or the ocean we're talking about. And I think something that you mentioned that's very common to a lot of states around the world is that we have really highly fragmented marine spaces with a lot of different legal frameworks. And unfortunately, law tends to complicate things. It tends to want to slice up marine ecosystems into different things and regulate them separately. So the answer to your question depends a little bit on what we're talking about. If we're talking about commercial fishing rights, for example, there was a big commercial fishing settlement done between the Crown and Māori at the end of the 20th century, which allocated quota rights out, and those are owned and regulated by Indigenous Māori organisations, as well as private commercial fisher people who might not be Indigenous. So that's how fisheries is done in relation to the within the territorial sea. The foreshore and seabed coastal region from high water mark and inland waters out to 12 nautical miles. That's an area in which there's been a lot of litigation. And we had a court case which recognised ongoing Māori customary title in that region. In the early 2000s, we've had a range of legislation and amendments to legislation passed, but we currently have a system under the Marine and Coastal Area Takutai Moana Act, in which Indigenous peoples can go to the High Court and seek a determination that they have a title, they have a customary marine title in that zone, and then that entitles them to a range of different rights and also obligations. So the area is treated different from fisheries, and then we have a separate settlement regime for aquaculture. We have separate rights as part of regional planning, coastal planning. We have different regimes for minerals and petroleum, different regimes for energy, for wind, for oil and gas, I could just keep going on because it's all fragmented, but in most of those spaces you'll have.
Yeah.
Sorry.
I was saying it's quite common, and it's actually been split in different boxes, regulation, depending on the type of activity. And it's something that we actually realized in the book, especially through the studies that have been conducted for the domestic practice, is that most of states don't have actually in place proper legislation for let's say, exploitation of deep sea minerals, the three main deep sea minerals, because the legislation they have is only for oil and gas and is not actually adapted to the type of challenges or specific risk that actually deep sea minerals raise actually. So yeah, it's quite common. But I imagine, as you mentioned, it was more the body of cases that you actually mentioned is actually closer to the coast, the territorial sea. I imagine the further you go out, especially the exclusive economic zone and the continental shelf, potentially more questions are being raised about this type of issues and control and title.
Yes, definitely. And there has been kind of an assumption that some of those area-based titles only go to 12 nautical miles, and the legislation only really applies to that space within the territorial sea. But I think it doesn't mean that the connection, the relationships and the rights and interests of the Indigenous people stop around where a line is ruled on the map. In fact, as Polynesian people, Māori would often say, I'm sure, that their rights go all the way to Hawaii, where their ancestors came from in the Pacific Ocean. So that is a contentious issue. But we also have recognition in our exclusive economic zone of Indigenous rights and protected by the Treaty of Waitangi. And actually, in the very famous case that I think we're going to speak about later, the TTR decision, the Supreme Court said it actually called out this ruling lines on maps approach and said it was quite inconsistent with an Indigenous cosmology. In fact, they didn't see a line between the territorial sea and the EEZ, and it was a case in which the effects were crossing that line anyway, so it made that point even more important to make.
It's very interesting. Is there also, because I know a bit more actually the system in place in Polynesia and New Caledonia, because they are French territories, overseas territories. And in both cases, specifically with regards to the moratorium they have adopted on the exclusive economic zone, the moratorium actually recognize not traditional rights, it's not Indigenous rights, but cultural rights, specifically on the management and the preservation of hydrothermal vents, so the chimneys, which are recognized as a place where the soul rests. Yep. So even if it's not under the hat of Indigenous rights, it could be, there could be insertion of cultural rights into the management actually of these spaces, I will say marine areas. Do you have like a distinction between like these two, of course, in New Zealand, where in some instances it's, the strong Indigenous rights of a, land or resources, or potentially cultural rights that could be recognized also on marine areas and resources?
Yes, I think we do. I just think that here, if there are cultural rights argued for, or if the concept of cultural rights is used in reliance on perhaps international agreements or protections, then it's usually Māori, Indigenous peoples, or their lawyers who are making those arguments. We probably don't have the same cultural context where those arguments need to be made outside of an Indigenous context. But I think there are certainly applicable lessons across jurisdictions, even if they're countries that don't have the same sort of constitutional context, for sure.
Course. Yeah, it's always difficult to compare, a jurisdiction with that regard. There's something very, very interesting that I've learned actually through Robert, is the fact that New Zealand is extremely advanced in terms of sustainable management. And I think the concept is really specific. So usually people know the concept of sustainable development, which is, the wording that is used by the UN. Sustainable management is a bit different and really specific to New Zealand. So I wanted to dive a bit more into it, specifically in regards to the management of natural resources. Can you tell us actually what is sustainable management and what actually makes this concept special in New Zealand?
So, paying respect to Robert, and his PhD research was very much about that principle of sustainable management and how that applied in the marine area. I actually, sometimes we would have discussions about the principle of sustainable management because I'm probably less of a fan than Robert was. But I think also some things have happened in the last few years since we published this chapter. The concept of sustainable management is really coming under fire in Aotearoa, and we're seeing it being removed from various pieces of legislation. So it's in the EEZ Act, of course, and it's also the fundamental purpose of our Resource Management Act, which is our main planning law that applies to the territorial sea and to the terrestrial area. And it really is about acknowledging that we need to live within the life-supporting capacity of ecosystems. And it resembles in many ways the principle of sustainable development internationally. Where it's been problematic in New Zealand, and I think it's probably the same in other countries, is that it's a bit of an oxymoron. Well, definitely sustainable development is a little bit. You've got sustainability on one side, you've got development on the other side. Where do you draw the line between the extent to which you can use or exploit the environment versus the extent to which you have to protect it? And we've had a bunch of cases, including in particular in the fisheries context in Aotearoa, that have gone to the highest courts, and there have been a lot of arguments from different interest groups about where that boundary is between sustainability and economic development. And our courts have sort of reached a point where they say, no, there has to be an environmental bottom line. So there's a point within which you can't damage the environment. You have to put the environmental preservation or protection first. And then that's become quite political. So in our current government, we have a coalition right-wing government at the moment, and they are looking to move away from that principle of sustainable management and create something new, something that they feel is less uncertain in terms of the balance between those two issues and going to lead to less litigation. I don't know if that's the case. And actually, our previous government was also moving away from it, but they were going to remove sustainable management and replace it with a principle called te oranga or te taia, which is a Māori principle, which means you put the health of the environment first, and that comes first. So they were really trying to be inspired by this environmental bottom line approach, which could be consistent with kind of an international precautionary approach. But yeah, we're really seeing the idea of sustainable management and sustainable development, which it comes from, being quite contested in Aotearoa in the last few years. And I'm not sure that it's going to hold its place as a fundamental principle underpinning environmental management into the future.
I mean, the main issue are actually linked to, the content and the implementation actually of this concept. And that's why it's been contested and interesting. I think, the concept, internationally, the concept of sustainable development is facing exactly the same type of issues. There's so many of interpretation and how you navigate conflicting interests, in terms of environment, social, economic considerations. It's extremely complex. And I will say body or concept of sustainable management. Since it's supposed to reconcile, different type of interest, I imagine you have the state and the Maori interest as well. Do Maori have the same type of environmental stewardship or sustainable management vision than the one that was expressed in the sustainable management? Or, potentially the idea of introducing the new concept, the Maori concept, is more in line actually to reconcile the divergent potentially vision of environmental stewardship.
Yeah, I think there was a lot written by Māori lawyers and philosophers and experts that was quite critical of the idea of sustainable management, or at least on the idea that you have to either use or protect, because in a Māori worldview, the way that I've read it, and I've said, because I'm not an Indigenous person, but I've spent a lot of time as a lawyer and as a researcher working with Indigenous groups and for them, the way that they explain their positionality towards the environment is often that they do use it. They like to fish, they like to eat the fish, but they also want to protect the environment so that it can continue to provide those benefits to people. So it's much less of a Western idea of either we use, exploit, or we lock it up in a marine protected area. So, for example, there's been a lot of controversy and opposition from Māori against marine protected areas because that stopped them from being able to use their commercial fishing rights and their traditional fishing rights too. I think that there would have been some aspects of sustainable management that would, be consistent with maybe with what Māori were trying to achieve, but something that's less binary, would be more in line, I think, with an Indigenous worldview. And that was part of the unease with that principle. But what we're seeing now actually is a move away towards something that's more enabling of development rather than protective of. We're actually seeing the balance shift further the other way,
which is not good either. It's interesting to see the contrasting perception of environmental management, like the Western one trying it's always falling into the extreme, and eventually the more balanced, reasonable one of Indigenous people. But when it comes, if I stick to the EEZ Act, the Exclusive Economic Zone Act, and the sustainable management, how this idea of sustainable management is implemented for marine natural resources, for example, fishing or minerals, for example, or sedentary species on the seabed. Does it rely, I imagine, a lot on environmental impact assessments and, of course, baseline information to be able actually to understand where the sustainability is or would be in the management of resources?
That's been a really big problem, the lack of information. And I think you mentioned that at the beginning. It was something that Robert was really concerned about because, yes, the principle of sustainable management, the Western principle of sustainable management, does depend on having adequate baseline information. There's a lot of territory to map around a small country like Aotearoa. It costs a lot of money. It costs a lot of funding of research organisations, collection and management of data. And we have quite poor environmental monitoring across both the terrestrial and the marine context, and poorly funded by the government, increasingly underfunded. So that makes it quite difficult to make those decisions. So a lot of the cases where they've become controversial and contentious and they've gone to the courts, they've been about finding that balance between managing environmental effects, but they've often also been about acting with precaution because there's not enough information. And in particular, often proponents of resource development in marine areas, they want to use an adaptive management approach, for example, where they want to kind of suck it and see how they go, do a little bit, then adapt. And that's been really controversial before our courts because the courts, what they've said, especially our Supreme Court, is, well, you can't do that unless you've got adequate baseline information. You can't apply an adaptive management approach because the ocean's too big and too unknown to be able to do that. And the potential effects are too significant to be able to justify that approach. So it's a problem. I think those of us who are working in marine areas, people like Robert and me and Hamish Rennie and many of my scientist colleagues who I collaborate with, we are constantly urging the government to put more funding into research and monitoring.
Why do you think? I mean, it's the case in many states. So, I mean, not saying that it's reassuring, but it's like for sure a global trend to not, dedicate enough funding actually to research and understanding the marine environment, even within national jurisdiction. Why do you think it's the case actually in New Zealand? It's just not a priority, or?
Yeah, I think we're a relatively small nation, but also, as we mentioned with a large EEZ, there's a lot of ground to cover. I think our marine territory is 10 times our land mass. Yeah. And so there's a lot of space and there's a lot of depth to cover. But I think too, I mean, that's exactly why the precautionary approach and precautionary principles developed, was to use precaution if the impacts and the effects are not sufficiently known in order to be able to manage them sustainably. Yeah. And we have had some court cases that have kind of reversed that approach and said, oh, we don't have enough information, so we'll let this go ahead with an adaptive management approach. But it's been good to see cases like the Trans-Tasman Resources case where the Supreme Court said, no, that's not appropriate for the marine environment. And I think too, in terms of the data and the information, the funding, we have a Parliamentary Commissioner for the Environment, which is an institution that we have within Aotearoa, who has a role to report to Parliament on environmental issues. And the Parliamentary Commissioner has time and time again raised this issue around state of the environment monitoring and data collection and data management and federation of data sources about environmental impacts, and keep saying to the government we need to do something about it. And it sort of seems like that message is not getting across at the moment, especially not with the current government. But we are also in an election year this year, so hopefully things improve in that respect.
Yeah, I hope so too. I'd like to go back to the question of the topic of co-management and governance actually of marine natural resources. But maybe potentially before diving in, would be good actually for the audience to understand, for those actually who don't know anything about Maori's rights and how, New Zealand is structured in terms of governance of co-management. Can you tell us a bit more about it? Because you mentioned in your chapter that there's a Maori advisory committee when it comes to the EZ Act, if I'm right. So we'll be will be very interesting to understand, how this co-management take place, what type of power do Maori's rights or Maori's communities really have. Is it consultative? Is it decision making? Is it a veto power? What type of bodies do they have actually within the governance, of natural resources? Basically, how it's being implemented, this co-management.
Yes, and I would like to say that there's a simple answer to that question, but like our marine regulation generally, it's highly fragmented, so it sort of depends what we're talking about. Mm-hmm. But if you go back to first principles, it's all about Te Tiriti, the Treaty of Waitangi, which recognises those ongoing rights of authority of rangatiratanga by iwi and hapu over their natural resources. And so as a result of that recognition, there have been all sorts of collaborative governance regimes develop in different ways over time. And there's also been allocation of just rights. And those rights come because some governance comes with that. So if you have a large proportion of the fishing quota, then obviously you have some governance rights in terms of managing how your commercial fishing operations are carried out. If you get a customary marine title in the territorial sea, then you have a range of governance rights in terms of how that area is managed in collaboration with regional authorities. And under the EEZ Act, there's a bespoke regime, as you mentioned. There's a recognition of the treaty and the rights of iwi and hapu under that. And then there's an institution established, which is this advisory committee that works with the Environmental Protection Agency to advise them in relation to the allocation of marine consents. And that's quite bespoke to that legislation. It doesn't look exactly the same as what you might see just across that 12 nautical mile line, or what you might see in a fisheries context or in an aquaculture context. The issue of collaborative governance, I use that term now because the term co-governance has become a real political football in Aotearoa in recent years, because there's been a lot of misinformation and a lot of scaremongering by certain lobby groups about the impacts of collaborative governance on non-Indigenous settlers, descendants of settlers who feel like they're being threatened by these sorts of approaches. So I think maybe 5 years ago, it's probably around about the time that we were working on some of this research with Robert, there was a real impetus towards these collaborative governance regimes where groups of Māori tribal groupings would be working together with local authorities and central government authorities to collaboratively manage natural resources, and to do it in accordance with Indigenous custom, and to do it generally on a consensus type approach. And that was, I think that was going really well in lots of different contexts, but there was kind of a backlash against that. And what's happened now is that we're seeing an unraveling of a lot of those things. We're seeing an unraveling of collaborative governance regimes, certainly under the Resource Management Act, and we have a bill up to replace that at the moment, which is before Parliament, which just removes all of the collaborative governance regimes that were in there. The EEZ Act, I just checked it before this interview just to make sure, and I don't think that they've got to it yet, and they haven't removed this Māori Advisory Committee, but I would say it's an important mechanism to have there. It's not one of the stronger ones that we have compared to some other legislation. Again, I'm hoping that this is a bit of an anomaly point, because what we're also seeing right now is the government is proposing to standardise all of the treaty references across all of our legislation, all of our environmental legislation. They typically have a clause that says that they'll give effect to the principles of the Treaty of Waitangi, or that decision makers must take into account or have particular regard to the principles of the Treaty of Waitangi. And the government's proposing to standardise them all to the lesser standard, which is take into account. So they just have to take it into account.
Okay.
They don't have to give effect to it. So we're really in a state of quite a lot of uncertainty in relation to our legal frameworks at the moment. Yeah, I think that's the short answer.
I can imagine there will be a lot of legal disputes actually arising from these changes.
Yeah, definitely.
Yeah, but I mean, the original idea of co-management, you mentioned that it really depends on, the type of resources and actually where the resources are located. What type of, grosso modo, the main differences between, for example, a land resource and a marine resource in terms of co-management? Do you see very big differences or not really? Actually, it's really by families of resources, or, the resources the most used or the most sought that have like a sort of a sophisticated, co-governance framework that has been put in place?
Yeah, I think there is a difference. I think that the most sophisticated collaborative governance regimes that we have are actually in a terrestrial riverine context.
Yeah.
So probably many of the listeners would know about the Te Awatupua Wanganui River Claims Settlement Act, which is a piece of legislation which recognises that the Wanganui River is an integrated living whole from the mountains to the sea, and that it has its own legal personhood. and has arisen out of a treaty settlement with the Wanganui iwi, and that is a really wonderful collaborative governance approach where the iwi have a range of different institutions that have been created under that legislation where they're working together with local community groups and also extractive users of the river. And that settlement, it's quite interesting because it goes out the river mouth, it's a tidal river at the ends, and it goes out into the ocean. So that technically does apply in the territorial sea, that approach. But definitely, I guess, on land and next to water are the main areas where we've seen a lot of collaborative governance between local governments, regional governments, and tribes, because iwi and hapu, Indigenous tribes and subtribes, they're tribal groupings. As you said earlier, like when the further you get out to sea, the less strong those collaborative governance approaches have been. There's still things there, and that's where in particular the TTR, Trans-Tasman Resources Supreme Court case was really important because it kind of filled a gap. It kind of tied it back to the same sorts of arrangements that we had in the territorial sea in terms of what's required of the Crown. But yes, what we do have in the meantime is this protection of Māori fishing rights, which is really powerful under the commercial fisheries settlement, and aquaculture too. And that again goes back to this, the traditional nature of the Māori economy, which was very much a fishing-based economy.
Well, it makes sense actually that
they weren't mining the seabed,
for sure.
It's important to them, but yeah.
So maybe we can focus now a bit more on the the cases that Robert actually was working on. He's been one of the lead counsel of the TTC cases going up to the Supreme Court in 2021, and it's been really a fascinating journey, these cases, because they went to the Supreme Court, means that there's been a lot of legal battles actually beforehand. Can you tell us a bit more? I will say in simple terms for people who don't know anything about, this journey of legal battles when it comes. It was actually the case of mining of iron sands. So it was not deep sea mining. It was seabed mining, not the three mineral resources we usually mention, but just, as a bracket, even though they are not these three deep sea mineral resources that are recognized internationally. In most cases, the seabed regulation actually is the same for any type of resources. So you don't really have a distinction between, mining polymetallic nodules or mining other type of resources, because even at the international levels, the regulation that had been put in place by the International Seabed Authority could actually be extended to other type of resources. Doesn't mean that it's going to stay forever with the same three resources. So this case is actually quite specific. Yeah. So tell us more, please.
Yeah, it's a landmark case for Aotearoa, but I think it's an interesting case internationally as well, and we say that in the chapter. And yes, Robert had a really important role. He was acting for a number of fisheries interests. It was a very long case because it started with a panel that was delegated to make the original decision on the marine consents. That decision was delegated by the EPA, or the Environmental Protection Authority, and then it was appealed up through the High Court, the Court of Appeal, and eventually to the Supreme Court. We got this really fantastic decision. And the decision has been useful for a lot of reasons. First of all, it prevented some seabed mining that on all accounts of the science would have been quite damaging to. Actually, a lot of the effects were going to be in the territorial sea. The sediment plume that was going to be created by this mining of iron sands was going to create a large plume. And that's where the fisheries interest came in too, because there were going to be impacts on fishing quota holders in that region. There were also impacts on the future rights of MACA claimants, so that legislation I mentioned, the Marine and Coastal Area Takutai Moana Act. There were groups who didn't already hold customary marine title, but they had claims registered, which still needed to be heard by the High Court in the future. So they had future potential rights and interests in that area. The court in that decision did a really cool thing. and that they looked to international law in terms of the United Nations Convention on the Law of the Sea and some other provisions, international treaties, the Convention on Biological Diversity, and agreements that are referred to in the EEZ Act. But in Aotearoa New Zealand, our courts often have been quite dismissive of international law domestically. They often just kind of ignore it or say it doesn't really add anything. So in this case, they really did go in quite a lot of depth and look through UNCLOS and some of the advisory opinions by the International Tribunal for the Law of the Sea, and bring in the precautionary principle to the interpretation of that, of whether this seabed mining, these consents could be granted. And all of the things we were talking about earlier, like inadequate information, the use of an adaptive approach when you didn't have adequate baseline information, those were the sorts of things that the court said were not okay based on applying the precautionary from international law. They also made a bunch of really useful findings in relation to the impact on existing interests, so the interests of the Indigenous applicants or respondents in the case, or applicants, I think, at that stage. And they said that it didn't matter in the case of MACA, for example, it didn't matter that those cases were still future. They hadn't been determined by the courts yet because they were customary interests which preceded, the arrival of the British here. And they also said that Indigenous Maori law or customary law, tikanga Maori, was part of the common law of Aotearoa, and so that could be applied in the case. So that was a really useful decision on that basis. They made these comments that I mentioned earlier about the arbitrariness of ruling lines on maps. So in this case, it didn't matter that the consents applied for were in the EEZ because they had impacts on the territorial sea. So you had to consider the impacts under the pieces of legislation that applied in the territorial sea too, like the MACA Act and the Resource Management Act. So in the end, we got a decision which was good because the result was right, and that the seabed mining, which was potentially really damaging to the environment, wasn't allowed to go ahead. But we also got lots of great law for a common law country like Aotearoa. That decision has been referred to in every single case about Māori rights and interests in natural resources since, because of the judgments that we got.
It was actually my next question. What has been the impact of this decision, in New Zealand? I imagine not just only related to EEZ and seabed mining, but since the decision has been actually recognizing, the importance of international law, but also applying a sort of ecosystem approach. Basically, when you blur the boundaries, it could have a very important impact, generally speaking, on the management of natural resources.
Definitely. And I think at the time that we published our chapter, we made that point that this would be a really important principle for ecosystem-based management, which has been kind of picked up here and there at different times in Aotearoa, but not really reached its full potential in terms of resolving this problem of marine fragmentation. But we keep, academics like me, we keep writing books and articles and chapters where we say that this is really important and it needs to get picked up. And I think it will over time, but there are it's probably the same in many other jurisdictions. There's a lot of resourcing that needs to go into fixing this problem of fragmentation. There's a lot of governance that needs to go into doing that. And it's going to take time and funding and political commitment. And we haven't really seen that, but hopefully we will. It didn't end with the Supreme Court decision. There have been further events since then in terms of this particular proposal by Trans-Tasman Resources, and that they continue to want to conduct this mining.
Yeah, I've heard about it.
Yeah, and the government, they did probably a significant amount of lobbying of the current government coalition. And this government has passed a law called the Fast Track Approvals Act just in the last kind of year or two. And that act allows consents that would be determined under a range of environmental laws, including the EEZ Act's marine consents, to be determined under that legislation by a hand-picked panel, which is picked by the minister. And that panel doesn't have to primarily apply the principles of the originating legislation. They have to apply a test which is whether the project will be of substantial benefit, national benefit to the economy and for infrastructure. So it very much like overturns this environmental bottom line approach.
Sorry, just a question. How can you not apply the precautionary approach? Because it's almost customary international law, actually. So it's not something you can disregard. It's something that you need to apply it anyhow.
I think that we probably need some test cases.
Yeah.
They might be looking for a barrister.
Yeah.
Because this is new. I agree with you. This is new legislation. As I mentioned, our courts have historically not had a very strong appetite for international legal arguments, but it doesn't mean that it can't be done. And the legislation also, the Fast Track Approvals Act, limits appeal rights in several ways. So to questions of law on judicial review. So they haven't quite had the right case to appeal. In fact, I don't think there have been any appeals of fast track determinations yet. Interestingly, for this one, TTR went straight to fast track and put in an application, but the panel recommended rejecting the consents, even under that much more enabling, development enabling test under the legislation, and for many of the same reasons, because of the environmental effects being too significant, being not sufficiently well understood, and impacts on Māori rights and interests. And treaty settlements, which is provided for in that legislation. And then once the panel decided that they wouldn't be approving it, the proponent, Trans-Tasman Resources, withdrew their application. So we don't really know where that leaves things in terms of whether they're finally given up or whether they're going to wait for a better time in the future. And we haven't had any other seabed mining, similar sort of seabed mining proposals get up in Aotearoa.
Okay. Very interesting developments, how things are, how much you can change a legislation to change the way, projects are being reviewed, and very interesting. But yeah, I do believe that anyway, precaution or ecosystem management, it's something that will need to come into play anyhow. So it will be interesting I'm looking forward actually to hearing about the cases also you mentioned regarding Maori titles in certain areas. Will be very interesting. Is it mainly in territorial sea again, or is it on the EZ? Yeah, territorial sea.
Yeah, that legislation only applies in the territorial sea, and it arises out of the Ngāti Apa decision, which came out of the Court of Appeal in 2002, which was actually focused on the foreshore and seabed, so the area between high watermark and low watermark, the intertidal zone, is what that case focused on. But the actual legislation, because there's a statutory regime now that applies in order to for those determinations of customary marine title, and that applies out to 12 nautical miles. There haven't been any attempts, as far as I know, to push beyond that 12 nautical mile limit, but I think they could, for sure.
Yeah, could, for sure. Yeah.
Because the connections are there, like, as you say, that as we were talking about, they don't just stop on a line with a line on the map.
No, because I mean the 12 nautical mile is a construct, of the end of the Second World War, basically. So it's the product of international law and the way we've been kind of cutting marine spaces in different boxes, but the way it's been cut and governed has nothing to do with ecosystem approach or continuity of rights or anything. So it's definitely something that could be challenged because this approach came from the 20th century, so it's quite new. For sure. So it's been fascinating. Thank you so much, Elizabeth. There's so much actually to look forward and to keep an eye on, actually. And I think for the audience, it will be very interesting actually to be able to understand how it works in a natural management, natural resources management work in New Zealand compared to other episodes in different jurisdiction. A lot of knowledge to share actually among all the experts. It's super exciting. Thank you so much, Elizabeth.
Thanks, Virginie. I look forward to listening to the other episodes too.
Thank you.